And Mr. Guillory, in cause number 2240982, on probation for unlawful possession of a firearm by a felon, that probation started last June of 2024. It was a 7-year deferred probation. Motion to revoke that unadjudicated probation has been filed. Looks like the primary two allegations are, one, that you have allegedly committed the offense of aggravated assault with a deadly weapon, June 19th of 2025, and also evading arrest or detention with a vehicle on that same date. The evading, has it not been filed or indicted? Okay.
Was it with a vehicle?
It was with a vehicle. That's at least what the administrative hearing says, but
I haven't seen anything about the evading. I think it was only my recollection was that it was evading on foot. I'm happy to explore it.
That's okay. Let me look at this as well. And so I'm going to take judicial notice of the court's file in each case. The new alleged offense of aggravated assault has been indicted in cause number 25 DCCR 090.
The courtroom fell silent as the judge read the charges. Aggravated assault with a deadly weapon, evading arrest, burglary. The man on probation had already been given a chance, and now the judge wasn't ready to risk another one.
And that I reduced that bond. And the new allegation, I'm printing out real quick the PC. I'm going to take judicial notice of that. Give me just a second to review it as well. Mr. Coleman has filed a response reply to those motions to reduce, and I have reviewed that as well. Give me just a second. It was on foot, yeah.
That's what I thought, Judge. If they allegedly
started on a bicycle.
Yeah, I don't know where they get the vehicle from.
Yeah, they wrote it wrong on the PC even. That's where it came from. All right, Mr. Lewis, do you wish to call your client?
So, ma'am, Judge, this is argument.
Okay, go ahead.
Judge, as far as with these motions, the motion to set bond, motion to adjudicate, of course, majority of this does deal with this new allegation. As far as the other conditions of probation Mr. Guillory had, it seems that he was doing well with that. He technically was not working at the time of the offense. He had basically a reduced workload. It was a layoff, but they have been called back to come back to work. He's trying to be able to bond out so he can get back to work, possibly even hire his own attorney, or at least be able to take care of his bills and things like that while we go through this process to take care of this case. So he definitely would like that opportunity, at least by having a bond set on it with the MTRP. As far as the new case,
he was already on a 7-year probation for gun possession. But when new violent crimes appeared, everything changed. The judge took one look at the file and decided this man wouldn't walk out today.
Secure any of the court's concerns with any public or private safety for the plaintiff witness or the general public while we were dealing with this, which could include, of course, GPS monitoring with a curfew would allow him to be able to go work and be back home to at least be able to take care of these things. With his job, he would be able to afford the monitoring and GPS monitor. He does have some support, family support. His wife is here today and has been here each time before she would come to court. And so that's what we ask for, Judge. Just, if they can get a bond that is a little more reasonable than $200,000. A bond that high, a lot of bonds from the courts. A lot of them won't even touch that amount. So
what is the status of the burglary of a vehicle in Hardin County from June 8th of this year? That's an allegation in the motion as well.
As far as I know, it hasn't been accepted or they've been going to court on that. My understanding. So the main issues that we were dealing with, of course, was he.
Well, that's obviously, that one is also important to me because that would be another felony allegation while he's on this probation. Let me see if the administrative hearing.
The defense pleaded for mercy, GPS monitoring, curfew, a chance to work again. But the judge saw something deeper: danger, instability, and a community that needed protection first.
Attached narrative or PC or something, and those are not always scanned in.
Are you looking at the court copy? It'll say court copy.
Okay, so the court copy should
Court
have
copy,
it.
'cause, it's not public.
Gotcha. No, that's perfect. That's what I needed. Give me a second. I'm going to print this out because this is... So, for the record, I'm taking judicial notice again of all of the court's file attached to the administrative hearing.
It wasn't just one mistake. There were new felonies, new violence, new risk. The judge reviewed the evidence and then said the words no defendant ever wants to hear. Bond denied.
In Hardin County and failed to report his arrest to his probation officer, and then GED, community service, and some things like that. Attached to it is the narrative from the Hardin County officer. Let me read that, and I'll give you both an opportunity if you would like. So this is allegedly a neighbor where the allegation is that Mr. Guillory got in their car, tried to start it and leave, that they confronted him, that he got out, walking up and down the driveway between the trailers, quote, freaking out, striking the trailers in his own vehicle. The officer also noticed kind of some erratic behavior, felt like he was under the influence of some type.
The courtroom heard about mental health struggles, a psychotic episode, treatment after arrest. But even that couldn't outweigh the judge's duty to protect the public. Safety came first.
Just dealing with mental health and checked himself in for treatment shortly after.
All right, so obviously I need that information because I don't feel like if that's going on that it would be in the best interest of our community to have a bond at this time. If there's something going on, then potentially we need to have some type of evaluation done ourselves to find out what that is and get that information to me. Based on all of the allegations in the motion as alleged, the burglary of a vehicle, the new aggravated assault with a deadly weapon, and the fact that he is already on probation for unlawful possession of a firearm by a felon, which means he's already a felon in that burglary of a habitation case, I believe. That was a conviction. I'm going to find, based on...
One man's second chance vanished in a single moment. Already a felon, already warned, now facing a deadly weapon charge. The judge's patience had reached its end.
And at this time, in cause number 22-40982, I am going to deny setting a bond in that case, and I'm going to deny the request to reduce the bond in cause number 25 DCCR 0902. And if you will get any information gathered together with regard to any mental issues, obviously that could go into play once we get to whatever point we do on what I'm going to do with the probation in the new case, and potentially for Mr. Coleman as well. If you feel like there's an issue with competency, let me know. It doesn't sound like that's the issue, but if let me know, we'll get a someone out there to see him as quickly as possible.
No problem.
All right, you can go back with the bailiff.
When the prosecutor spoke, the truth hit hard. Multiple violations, repeated arrests, and lies about what really happened. The judge didn't see rehabilitation, only a repeat offender.
Kaylin, welcome. And Mr. Parker, will your client waive the formal reading of the indictment? Mr. Welcome, in cause number 25, DCCR 1156, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from July 9th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand if I follow the agreement that you've reached?
Then came the final blow. The judge denied all requests for bond reduction. The defense lawyer could only nod. Justice once again had spoken with strength.
exclusion from admission to the country, or denial of naturalization under federal law. State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Welcome is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated.
Later that day, another man, charged with aggravated assault, stood before the same judge. He pled guilty. Calmly, the judge sentenced him to 7 years behind bars.
In that case, you will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or.
When the gavel fell, 2 men faced their fate. One denied bond, one sentenced to prison. The courtroom reminded everyone watching, mercy is earned, not owed.